The Supreme Court just ruled 9-0 that the federal government cannot automatically take your guns away just because you smoke weed. 9 justices. 0 dissents. But here's what the headlines are not telling you: this ruling has a very specific catch. And if you get it wrong, you could be looking at up to 15 years in federal prison. Stay with me, because the details here matter more than the headline. On June 18, 2026, the Supreme Court handed down one of the most talked about Second Amendment decisions in years, United States v. Hemani. And yes, it was 9-0. But before you celebrate, you need to understand exactly what the court said, and more importantly, what it did not say. Because millions of Americans are about to make a very dangerous legal mistake based on a viral headline. This video breaks down the real ruling, the real limits, and the one trap that could turn your legal gun purchase into a federal felony. Let's start with the man at the center of this ruling. In August 2022, federal agents executed a search warrant at the Dallas area home of Ali Danial Hemani, a dual U.S.-Pakistan citizen who was under investigation for suspected terrorism-related activity. Here's what they found. A Glock 9mm handgun in a bedroom closet, and about 60 grams of marijuana. Hemani cooperated fully. He admitted to smoking weed roughly every other day. Now, the terrorism investigation went nowhere, but 6 months later, the federal government came back with a single criminal charge: not terrorism, not drug trafficking. They charged him under 18 U.S.C. Section 922, G3, a provision of the 1968 Gun Control Act that makes it a federal felony for anyone who is an unlawful user of a controlled substance to possess a firearm. The government's entire case rested on one thing: Hemani smoked weed regularly. That's it. They never claimed he was high when he had the gun. Never claimed he was violent. Never claimed he was an addict. Just a regular cannabis user who owned a gun. Hemani's lawyers said that's unconstitutional. The district court agreed. The Fifth Circuit agreed. And on June 18, 2026, the Supreme Court agreed. Unanimously. But here's the real question: what exactly did 9 justices agree on? Here's where most people get it completely wrong. A 9-0 ruling sounds like a total knockout. And in one specific way, it was. The court held that the federal government cannot prosecute a sober, nonviolent marijuana user under Section 922, G3, based solely on the fact that they use cannabis regularly. That's a massive statement. But the court did not strike down Section 922, G3, entirely. The law is still on the books. It still exists. It can still be used, just not in the way the government used it against Hemani. Think of it this way: the Supreme Court didn't tear down the fence. They just drew a very precise line around where the fence can legally stand. Justice Neil Gorsuch, writing for the majority, was clear: this is an as-applied ruling. Meaning it applies to this specific set of facts: a sober user, not accused of violence, not clinically addicted, possessing a firearm at home. Step outside those facts, and the ruling may not protect you at all. Which raises the next critical question: where exactly is the line? To understand the ruling, you need to understand the government's argument. Because it was genuinely remarkable. The Justice Department stood before the Supreme Court and argued that disarming regular marijuana users is constitutionally valid, because back in the 1700s and 1800s, states had laws disarming habitual drunkards. That was their historical analogy. Modern weed smokers equal 18th century town drunks. Gorsuch didn't buy it. Not even close. The court broke the historical comparison apart on 3 levels. First, who was being targeted? A habitual drunkard in founding-era law was not just someone who drank regularly. It meant someone who drank to such extreme excess that they were practically incapacitated, unable to manage their own affairs, mentally incompetent, completely without self-control. Hemani held a job, cooperated with federal agents, and managed his own home. That comparison falls apart immediately. Second, why the law existed. Those old drunkard laws weren't primarily about public safety or gun violence. They were about vagrancy, family finances, and moral conduct. The government tried to dress them up as public safety measures. The court said, no, that's not what the historical record shows. Third, how rights were taken away. Founding-era laws required a formal legal process before stripping any right. A court hearing, a judicial proceeding, a conviction. Section 922, G3, does none of that. The moment you're labeled an unlawful user, your rights are gone automatically, with zero individualized process. And the court added one more devastating point. The government's own actions contradict their argument. The DOJ has been pulling back enforcement against marijuana users. Medical cannabis was rescheduled from Schedule 1 to Schedule 3 in April 2026. Dozens of states have legalized it. The court essentially said, you can't tell us marijuana users are categorically dangerous while simultaneously telling your prosecutors to stop arresting them. The argument collapsed. 9-0. But now the question everyone's actually asking. Does this mean you can walk into a gun store, say you smoke weed, and legally buy a firearm? This is the section that could save you from a serious federal crime. Pay attention. When you buy a gun from a licensed dealer, you fill out ATF Form 4473. It asks whether you are an unlawful user of a controlled substance. Here's what changed, and what didn't. In May 2026, the ATF published a draft revised Form 4473 that removes the blanket warning treating medical marijuana as an automatic disqualifier. This is significant. If you hold a state-issued medical marijuana card, and you use only state-licensed medical cannabis products, you are now moving toward a legal pathway to purchase a firearm from a licensed dealer. That is real progress. But recreational marijuana users, that is an entirely different story. Recreational cannabis remains a Schedule I controlled substance under federal law. That has not changed. No state law changes federal law. So if you smoke recreational weed and you walk into a gun store and answer no to the drug use question on Form 4473, you have just committed a federal felony. Making a false statement on a federal firearms form carries up to 15 years in prison, under the Bipartisan Safer Communities Act framework. The Hemani ruling doesn't touch this. The court's protection covers the status of being a cannabis user in the context of prosecution. It does not give you legal cover to lie on a federal form. This is the perjury trap. And it is real, it is active, and it will catch people who misread this ruling. Let's be direct about what the court left completely untouched. Active intoxication. If you are high, actively, presently under the influence, and you are in possession of a firearm, you are not protected by this ruling. Not even close. The entire legal basis of Hemani was that he was sober at the time of possession. The moment you're impaired, the government's authority to act is unaffected. Clinical addiction. The Supreme Court only ruled on the unlawful user side of the statute. The addict side, people who meet clinical criteria for substance addiction, was deliberately left open. The court did not say the government can never disarm addicts. That question is still alive. Felony convictions. If you have a prior felony conviction, nothing in this ruling helps you. The felon in possession ban under Section 922, G1, remains entirely intact. The court has repeatedly declined to revisit that provision. Recreational users at the point of purchase. As covered above, the Form 4473 perjury trap remains fully operational for anyone using non-medical marijuana. And one comparison that's worth making, because it's all over the internet right now. Hunter Biden was convicted in 2024 under the same statute, Section 922, G3. And people are asking, would Hemani have changed his case? The answer is almost certainly no, and here's why. Biden was prosecuted under the addict prong of the statute, not just the unlawful user prong. Evidence showed he was actively addicted to crack cocaine at the time of the gun purchase. And the prosecution included lying on Form 4473. The Hemani ruling specifically excluded clinical addiction from its holding. The court did not rule on whether disarming addicts is constitutional. And it did not address Form 4473 perjury charges for non-medical drug users. Biden's case sits squarely in the categories the court deliberately left unresolved. Hemani does not rescue it. Step back for a moment, because there's a constitutional principle here that goes far beyond marijuana. The court's most important statement may be this one: the government cannot grant itself the power to unilaterally designate entire categories of people as dangerous and strip them of constitutional rights without individualized process. Gorsuch's majority made this explicit. If the executive branch can use the Controlled Substances Act, a public health law, as a tool to automatically disarm any group it chooses to classify as a controlled substance user, then the Second Amendment becomes whatever the current administration decides it is. That's not a constitutional right. That's a revocable privilege. The court said no. And that principle, the requirement for individualized process before disarmament, will ripple through Second Amendment litigation for years. If you made it this far, you now understand this ruling better than most lawyers being quoted in the media right now. But here's the thing: Hemani is one piece of a much bigger legal puzzle, shifting around gun rights in 2026. There's another case moving through the courts right now, Wolford versus Lopez, that could change whether you can legally carry a firearm on private property open to the public. In states like Hawaii and California, the Hemani decision directly shapes how that case will be decided. If you want to understand where gun rights are actually headed in the next 12 months, and what it means for you specifically, that breakdown is the next video.